Hi, I'm Matt Drake of Drake QS Limited. This series of podcasts concerns do-it-yourself construction adjudication. In this series, you'll hear information from Peter Vinden, the Chief Executive of the Vinden Partnership, Paul Jensen, the Principal at Paul Jensen Associates, Michael Pye, the Principal at Pye Associates, Richard Barnes, Senior Consultant of the Vinden Partnership, Kenneth Salmon, Solicitor at Slater Healis, and James Driver, Partner of the construction team at Clark Wilmot, with questions posed by myself, Matt Drake. We hope you enjoy listening. I'm sat here today with Richard Barnes of the Vinden Partnership, and Richard's going to talk today about presentation of submissions in the adjudication process. So Richard, to get started, do you want to tell us a bit about yourself, please?
I'm a chartered quantity surveyor. I'm also the chair of the local CIR branch.
Right, okay. How long have you been a chartered quantity surveyor for?
13 years, Matthew.
And how long have you been doing adjudication work for?
About 5 to 6 years now, Matthew.
So got some good experience.
And some bad experience.
Of course, yeah. I've noticed that you, what underpins the knowledge is also the experience, but also the qualification. You've got a Masters in Construction Law, is that correct?
Yes, that's correct.
Right, okay.
And I'm also FCI-ARB.
So a fellow of the Chartered Institute of Arbitrators as well. Yes. So you've got the good credentials, so basically the listeners are going to get some good information from you today.
Hopefully.
Okay, I'm sure they will. So to start then, do you want to just talk us through your view? Having worked for the referring and the responding parties in adjudication, you obviously get involved in preparing documentation for submission. Do you want to talk about certain things that you think are worthwhile for listeners to hear?
Yeah, well, I think the important thing is to establish what you're trying to do, and obviously to understand that in order for a claim to succeed, the obligation is on the claimant to prove its case on the balance of probabilities, which is the civil test, that the respondent has broken some express or implied term of the contract. So obviously at the start you've got to obviously find that there has been a term that's broken, and then once you can demonstrate that, then obviously find the losses that follow. Okay,
and is there anything in particular that you look out for? Because you mentioned there about breach of contract and where it goes wrong. Is there anything that you particularly look for in the documentation as a first port of call which helps you with your submission?
Yeah, well, obviously we check the contract terms to ensure that a particular customer of ours hasn't signed up to some onerous terms and obviously waived some of its rights by potentially, not issuing notices at the correct time, obviously signing up to condition precedents and all those sort of onerous things that we advise clients on a regular basis not to sign up to.
Right, okay. So let's hypothetically talk about this. I work for a subcontractor, and I've got an issue on a project, payment-related issue. Regardless of whether this payment-related issue is to do with a payment notice or it's a contentious issue regarding variations, if you're going to produce a submission, do you want to talk about the content of the submission in the sense of how it's structured? I understand you're telling a story to an independent person who knows nothing about the job. So how do you build that story? Is there a particular process you follow?
Not necessarily. Each obviously case sort of rests on its own merits, so that the approach you sometimes would take for a particular kind of dispute would differ from another. A lot of the time it's the experience. I think a lot of the time it's the preparation work at first, understanding what's gone on, why it's happened, what the obligation was. And sometimes, like for instance, a claim that I'm currently looking at, something has gone wrong, but there was a remedy that was reasonably low cost to resolve the issue. It should have been done in 2 to 3 days. It's been delayed by the main contractor, and you've ended up with the main contractor trying to charge a particular subcontractor £180,000 for delay as a result of its own sort of inadequacy. Again, getting your sort of your house in order at the start, so you've got to understand everything about it. In this instance, I was sent a Dropbox link for the information. I didn't actually print it off. I seemed to spend 2 weeks chewing through all this information. Then they came into us one day, so I asked one of the admin staff to print the stuff off. 2 days later, they finished printing the stuff off. There was 4 lever arch files of information. Kind of makes you understand why it's taking you so long on the Dropbox link. It can be a bit of a mirage sometimes, the old Dropbox links, because obviously you've just got a line of...
Yeah, you don't know what you're getting yourself into until you download the
and
link.
then you start clicking on the link and drilling down into the documents, and you open another document, and then you have emails within emails.
Yeah, it's a long-winded process, and that getting it right at the beginning is obviously... It's the most important factor, isn't it?
To sort of understand all the information that you've got, and possibly sometimes, to understand the information that you haven't got, and to request that your client provides you with that.
Well, if you think of submissions from the point of view of, it's not only the submission that you are making on behalf of your client, it's the submissions that they would have made earlier on in the contract, which you would refer to as evidence.
I mean, the contemporaneous records, which is obviously the documents that are produced during the currency of the works, they're obviously the sort of the vital piece of information that you probably have, really. You can try and fill the gaps with witness statements, but a lot of the time you find that the adjudicators will hone in on that contemporaneous documentation and what did or didn't happen. Where it becomes difficult, and a lot of parties fall into this trap, is where they do talk to each other. They don't, because they're in this discussion, they don't record what's happening on the emails. So again, going back to this recent case, the particular main contractor is complaining that nothing's happened for 3 weeks. Now, I don't believe that nothing's happened for 3 weeks. They've just been talking during that period.
Right, okay.
Because obviously if somebody's failed to provide a survey for 3 whole weeks and they weren't getting the answer that they want, I would have expected likewise the main contractor to have sent the subcontractor an email to say, you failed to provide this particular survey, can we have it?
Right, okay. So it's, the whole package is, it's not a case of a subcontractor coming to you and asking you to perform miracles. You do need information from them, and it needs to be in a certain format, in the sense of it's easy to follow. I mean, I suppose any record is better than no record, but you want certain records to include certain information. If we're talking about a delay on site, you need to be mentioning things along the lines of
the reason why it's delayed, what the effects of that particular delay are. Yeah, I mean, obviously our Magic Wand's in for service at the moment is the line that we give our customers when they want us to perform miracles.
Yeah.
There's only so much we can do.
So they've got to help themselves, really, haven't they? They've got to come to you with the bones of a case that you can pull together.
Yeah, that's exactly it.
So back to the hypothetical scenario. I've come to you now. I've got my contemporaneous records. Yeah. Let's change the scenario from a payment one to a delay one.
Yeah.
But it's obviously, this one's requesting an extension of time. Yeah. Just give me some of the headliners that are in that referral document, in the sense of, if we were going to go through like a contents page, what's the first thing we're setting out?
Yeah, so obviously, as you rightly identify, the starting place is a referral document, which is essentially setting out the dispute that we are going to refer to adjudication. So typically, depending on size, we generally have an index at the start of the actual referral. Sometimes you have an executive summary. Some people like sort of telling the story over and over again. The executive summary can be a good tool to do that. We identify who the parties are, who the parties are to the actual dispute, and then who the parties are to the contract, because they're not necessarily the same people, just again to set the scene for a particular adjudicator or the person on the other side reading it. Then we provide a narrative of the overall dispute, which is essentially who, what, where, and when, and obviously those background features. Then we provide an explanation as to how particular contracts applies, and again, that's sometimes a subject of contention between the parties. You can have two opposing views. One particular contractor will say that their set terms will apply, and the subcontractor will say, no, I've not accepted those, and it's my terms. So we try and set out the position as to set the stall out. These are the rules that we're playing to, and this is the basis we're going to go on. And then we provide an assessment of the claim that's been made, or the claims being made. Obviously, it's difficult in adjudication without the consent of the other parties to actually refer multiple claims to adjudication. So we have to be careful there to ensure that we stick within the rules that are set out by the particular contract. Then we'd obviously set out that, what declarations are required for the adjudicator. So obviously, if we're after a sum of money to be paid, or a grant of an extension of time, or maybe even loss and expense, we'd set them out. We'd request a date for payment, we request interest, and more importantly, who should pay the adjudicator's fees. But obviously what we can't sort of stress the importance of is that all this information is supported by the evidence, which is the records. There's no point coming to us with, an empty lever arch file, because we cannot fill that up for you.
Yeah.
We can only work wonders from the information that you've got. And again, it's the quality of that information that we can't really overemphasize. It's at the time, it's recording at the time. If you know you got a problem, spend that extra half an hour a day recording that, because ultimately, that's going to either win you thousands or cost you thousands.
Yeah, I mean, you've made good points there in relation to records, because the other interviewees have all mentioned so far that records are important. Records is all I keep hearing, and that can't be overemphasized enough. So it's obviously well placed for you to mention it there. But just to recap, so we've got the content of the referral document, an index, the parties to the dispute, the contract, a background of what the dispute is, and then you get into then actually why the dispute has arisen. Yeah, and which clauses of the contract you're relying on to support your claim, with reference to an appendix or a series of appendice files, which is the records which you'd hope the subcontractor has prepared.
Generally, I mean, again, it's a preference of personal style, but I use footnotes. Right. So wherever a state of fact, I'll put a footnote by it, and then a reference in the appendix. Yeah. It's quite easy then to know that, what I'm saying is supported by some documents. Yeah. When the other side hopefully comes back to you and they start slinging allegations around, but they can't cross-reference them to any appendices, well, where's the adjudicator going to go with that? You've got a fully substantiated document, or substantiated as much as you possibly can, because you're never going to evidence everything, unfortunately, which is quite annoying, because it's always that sort of silver bullet that you're looking for. But if you had that silver bullet, maybe you wouldn't have a dispute. Yeah,
you're spot on there. So after we've set it out, we're asking the adjudicator the redress that we want. We want a decision in our favour for a particular length of time, or whatever time is determined by the adjudicator, or if it's cash, how much you want paying, or whatever the adjudicator determines. Also, the awarding of interest on any late payment, if there is one. And then also, it's who's going to pay the fees of the adjudicator, which is quite important. And from experience, predominantly, the losing party pay the fees of the adjudicator. Have you noticed anything different recently?
No, predominantly the fees can be apportioned in different ways as well. So they can be apportioned on an issues basis, whilst there's a risk associated with that. So perhaps if you referred 8 issues to adjudication and you were successful in, say, 6 of them, but you lost on 2, you could end up with a 25% share of the adjudicator's fees. But generally what we give advice clients about is we can't really predict how an adjudicator will decide, although we can generally have an idea, but we get quite often surprised. Because again, you don't know what the other side's going to give you back, and the way in which the adjudicator views the documents that you've put forward, because obviously everybody's got a different opinion. And it is an opinion at the end of the day. You've got to remember that an adjudicator is allowed to be wrong, and that even when an adjudicator is wrong, those decisions are enforced by the courts. They've got a very privileged position.
They have, which has been discussed, no doubt, many times in more different forums than this. So let's go back into a hypothetical scenario. We're in the process. We've issued the notice of adjudication. We've appointed an adjudicator from a body. We've issued the referral. Adjudicator has confirmed receipt of the referral. The process is underway. The document then which the adjudicator now seeks, should the other party be willing to participate, is
the response. But just to sort of go back, obviously we talked about preparing the referral. And what we generally do and what we generally advise is that you don't produce your notice of adjudication, which is essentially the initial document that kicks everything all off and, puts your hand up to the other side and says, we've got a problem and we're going to go to adjudication. That document is, is kind of required under the scheme anyway, as the document that needs to be issued out to obviously all parties to the contract to make them aware, and then from the issue of that document, they can then go away to a nominating body, whether it be the CIR, CEDA or somebody else, And then they would then appoint an adjudicator based upon the documentation, not only on their application form, but within that actual notice of adjudication. So generally, it's advised that you prepare that notice after you've finished your referral, just to ensure that the dispute you're referring in your referral document is in the notice of adjudication, because that notice of adjudication is the cornerstone. Whilst the adjudicator enjoys a very privileged position and he can be wrong, he only gets his jurisdiction from that particular notice of adjudication. And if there's something not covered by that notice of adjudication, or it's too narrowly worded, then he lacks jurisdiction to deal with that particular issue. So if you've referred in your notice of adjudication 2 invoices to adjudication, but for instance, you throughout the process, you discover it's actually 5 invoices, he's only got the jurisdiction to look after those 2, unless the other sides agree. Generally, you find that the other side won't agree to anything.
So you'd either have to stop with the process and start again,
which can be a very expensive process, especially once the adjudicator on board. Again, we generally advise, or I would generally advise clients, if there is an issue with notice of adjudication and you haven't got the adjudication on board, just correct the issues and move on, because that can create lots of challenges when it comes to enforcement. And I'm sure that some of your other participants in this stream of podcasts will be advise you the costs of those enforcement proceedings. But if you think the adjudication is expensive, then
Okay, so you thanks for just clarifying for those people, the listeners who wouldn't be aware, that the importance of referral, get that ready, draw out the notice, write the notice, and then it's notice, referral, response.
And then obviously the next submission would be from the other side, which would be the response. There's many forms of contract that identify a requirement for a response, but under the Act and the scheme, there's no actual sort of statutory right anyway to a response. But in the interest of natural justice, the courts have provided the parties with the ability to essentially feedback, which if you go into court, you probably term it the defence. And the response really should answer every point that's made in the referral notice and clearly set out each point that's either agreed or rejected. And obviously, if you're going to reject a particular item, it's always a good reason to say why you reject that particular item. If you can rely on a point of law or a point of the actual term of the contract to assist you, then, it's good to reference those and include those as well. And again, records, if you've got records that discredit the other records, then by all means, chuck them in and bring those documents to the adjudicator's attention.
So when we were speaking about the typical order or layout of a referral document, is there a particular structure that you would have that you follow for a responding document if you are a responding party?
We generally set out that we provide a sort of an all-encompassing column that, where if we don't actually answer an individual point that is denied, just to avoid anybody assuming that it's been admitted. But I would generally advise people to, where possible, respond to not necessarily every point, but every issue that's been referred.
And that would you get straight into that with the response, or would you put things in like, we're the responding party, this is the referring party? Would you do that, or just get straight into it?
That's a question of style. Personally, I don't bother, provided it's obviously been set out in the notice of adjudication and or the referral document. They're agreed facts. I maybe, if they've numbered it 1.1, maybe agreed. Sometimes don't even bother. Because obviously you're spending clients' money for them. Yeah. They're paying lots of money. There's no point telling people what they already know. Yeah. And as a matter of fact, it's quite clear.
So is it in the benefit of everybody, in your opinion, then, that if you do agree on points from the referral, to set them out rather than to be more proactive in the process, to really narrow down where the adjudicator has to decide, as opposed to, is that the style you go for?
I personally go for that style. Other people go total guerrilla warfare and deny everything. I personally find it very uncooperative and unhelpful, but each their own. Who's to say which style's right and wrong?
Yeah, I suppose. Yeah, you're right.
But
I think
ultimately, you're trying to convince the adjudicator that your side's right and their side's not, and
so it's the best argument, the most persuasive argument, backed up by evidence and contractual entitlement.
But I think conduct does play to you in an adjudication. I think if you generally do the right thing, then that's going to provide some sort of sway on the adjudicator.
Okay, and I mean there are obviously different documentation stages. So an adjudicator has now received a response from the responding party. The adjudicator may be satisfied with a referral and a response, but most often they actually ask for...
Well, yeah, I was, again, as the referring party, having received a response, there's no automatic right to reply, but, if there was something that I didn't agree with, then I'd be suggesting to our client that we request the opportunity to reply to that document. And again, depending on the timescale, you could have 24, 48, 3 days to do so. If you had an extended time, you could have a bit longer.
Okay.
And hopefully, those particular documents would reduce in size as you get, later on in the process, because you shouldn't be reciting the same issues over and over again. You shouldn't really be introducing new arguments, to say the least.
Yeah, and it does make sense for them to narrow down, because you've got the first batch of issues which are in the referral. Yep. They've hopefully set out where they agree in those areas they don't agree with, and then your task then is to set out why the areas they don't agree with should be perceived in your favour, so that it naturally would thin out the document. What happens if the adjudicator invites the responding parties to submit a document after the reply? What's that called?
A rejoinder.
A rejoinder. And again, it's just following the process of asking the responding party to comment on any of the comments in the reply. Again, narrowing the issues even more.
Yeah, you generally find that adjudicators won't necessarily invite people to make submissions. He may set a timetable out, she may set a timetable out at the start of the process, but very much so, I think the adjudicators try not to encourage you to make sort of further submissions throughout the process, and they will try and close that down throughout the process, because you find invariably these end up mentioning the same thing time and time again in each of the submissions. What also probably is a very good point to point out is that obviously when you're producing your referral, you don't have any time pressures. So as a referring party, you can take as long as you want, because it's only your own internal. Obviously, and as a result, I would sort of strongly advise any party to deal with all those issues in the referral as much as they know, and to consider every single one of them.
Because you don't time bad, so to speak.
Because you don't want to ambush yourself, because obviously, you're going to give this referral to the other side, and they may get sort of between 7 and 14 days to reply, or to not necessarily call the reply, but to respond. And then obviously, that hot potato's back to you then.
And you may only have 3 days.
And you may only have 3 days.
And to issue a reply.
If you've not dealt with 50% of your issues in your referral document, well, suddenly you've just found you gave yourself 3 days to deal with all this volume of information that you've potentially held back, and you kind of ambush yourself, really.
Yeah, it does really bring to the point about taking your time with the referral, doesn't it? And having those conversations with the client about what issues they want resolving.
And as a result, I don't think there's any surprise that sort of 65% of sort of referring parties are successful in adjudication, because you think about it, you've got that ambush opportunity, you've got the time to prepare your claim.
Your case,
you pick the question as well, which is another one. When you're doing your homework at the start, you're finding that question that's essentially your client's strongest point, and you're referring that particular dispute. So if there's an angle that you can find, and perhaps not necessarily it resolves the entire dispute, but it provides you with some opportunity to go ahead and negotiate, or to get some interim relief for your client, perhaps because the strength of the case isn't that strong, well, that's what you should be doing.
Okay. After notice, referral, response, reply, rejoinder.
Yep.
Next one's a surrejoinder,
Yeah.
which is issued by the referring party,
Yep.
which would then be their third submission after the notice during the process. And again, not to go over all ground, it's just really answering any final points. But because the adjudicator has 28 days, unless extended by the referring party for 14 days or beyond that by the consent of both parties, you can understand why an adjudicator doesn't invite any further submissions after a reply. But then again, they can't really deny a responding party the opportunity to answer a reply with a rejoinder, in the sense of if the adjudicator's time frame of the 28 days is limited, the responding party might decide to issue a rejoinder on day 24, as an example, which, and not to be in breach of the rules of natural justice, they're not going to prevent that from happening. But so you can see why adjudicators try to control the amount of submissions from the parties. But question I've got for you, what's after a surrejoinder?
A rebutter.
A rebutter, right, okay. So we've spoke about, in terms of the submissions, we spoke about the notice and how the notice should be prepared following the construction and getting ready of the referral. We've talked about the setting out of that document about in the referral. This is getting the parties correct and the contract and what the dispute is, and then what's gone wrong, what the contract is, how the contract applies in your favour, and then what redress you want, plus the earlier correspondence between the parties, which is the contemporaneous records. And also we spoke about the responding party and what they do and how you, if you were working for the responding party, would set out your document. But is there anything else? Is there, in terms of the quality of the submissions, can you think of any other good advice you would give to listeners of this podcast about what they, if they were preparing the documentation themselves, what would you give them? What, if top 5 things come to mind, what would they be?
Well, the document has to be professional. So obviously spell checked, correctly punctuated, grammar, nicely presented. Don't really use 4 ring binder folders because they're quite difficult to work with. 2 ring binders are always better. Paginated, again, in accordance with the adjudicator's instructions. A lot of adjudicators now ask for the documents in the native form. So that obviously if you provide them with a copy of the Word document, so again, they can copy and paste from your submissions into their decision, saves them typing out. If you're paying somebody £300 an hour, you don't really want paying him just painfully type.
Yeah.
At the pace that, some adjudicators may type, and it might not be as fast as yours, although his hourly rate is probably significantly higher.
Yeah. Okay, and then the same I would really apply to the supporting correspondence in separate files, should they need to be in separate files. So the appendix type of information, that needs to be...
Again, with dividers, so again, if we've got appendices number 1 to 47, every appendices will have its own divider behind it, and, a list of the appendices as well.
So an index, a front index
find it quite easily.
And then you would obviously make sure that links correctly with the documentation, the referral or the response, whichever document it is, or anything else in that process of reply and rejoinders. You'd make sure that I think the best way I would say to explain that process is that you would want this document to be picked up by somebody who doesn't understand much about construction, understand much about the project, and be able to read through, and after they've read through, come away with an understanding of what's gone wrong, why it's gone wrong, and what evidence you're relying on, and what you want to be done about it. And if you can set it out that way, you're doing quite well, aren't you, in the sense of trying to get a decision in your favour?
Yeah, no, we use, again, it's wrong to assume knowledge of anybody, even your adjudicator, because you don't know necessarily what discipline the person's going to be. So I was trying to work on the basis that, if an intelligent 10-year-old could pick up my document and understand the dispute, I've done my job.
It's well written, yeah. Okay. I suppose coming towards the end now of this podcast, is there any kind of, aside from talking about presentation of submissions, which is the purpose of this podcast, what particular advice would you give to contractors, subcontractors, clients who are listening this about adjudication or about construction generally? Is any top 1 or 2 things that come to mind that you would give them as advice?
Yeah, I think if you feel that you're getting into trouble, seek advice early. Don't leave it too late. Again, the earlier the involvement, have a contract review, know what your obligations are under that contract, know what you need to do if things are going wrong, know what notices you need to submit, know what records you need to keep. Get that early intervention, but equally, once it does start to go wrong, come and talk to somebody about it.
Yeah.
And even if you're going to be told, yes, what you are doing is correct, that's a good little nice pat on the head. And, it might cost you 150 quid, but it could
It's money well spent.
Save you thousands, or maybe hundreds of thousands in the cases of some of the disputes that we deal with, or even in others, millions.
Yeah. So basically, get your contract checked, know what you're signing up to, and know how to manage that contract.
Yeah, manage your risks effectively, and know when your risks are occurring, and be alive to those risks.
Well, brilliant. Well, thanks for your time. I'm sure the listeners of the podcast will appreciate the level of detail you've gone into about the submissions. So thanks to Richard Barnes of the Vinden Partnership.
Thank you very much. Thank you very much for coming in, Matt.